Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here this morning. This morning, we have our arraignment docket. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. The case that you have in this court is a misdemeanor case. We handle Class A and Class B misdemeanors. Cases are classified either as a felony or misdemeanor. The difference between those two types or those two categories, your felony cases, the range of punishment can entail that you can go to TDC, a Texas Department of Corrections, as a form of punishment. Normally we call that the penitentiary. With a misdemeanor case, you cannot be sent to the state penitentiary. However, for Class A and Class B misdemeanors, your punishment may entail being sent to the county jail. Now, there are three types of misdemeanors. One is called Class A misdemeanor, the other is Class B misdemeanor, and a Class C misdemeanor. Your Class C misdemeanors are normally what is referred to as your traffic tickets. Those cases that are in the JP court or in the municipal court. With those type cases, those Class C misdemeanors, your punishment cannot entail jail time. It's fine only. You only can get a fine. With a Class A and a Class B misdemeanor, however, as I said earlier, your punishment may entail punishment to or sentencing to the county jail. Now, for a Class A misdemeanor, which is our highest misdemeanor, your punishment can be anywhere from 0 days in the county jail to 1 year, 365 days, or anywhere in between. Your fine can be anywhere from $0 all the way up to $4,000 or anywhere in between. Or you could be given both such fine and confinement. For a Class B misdemeanor, the range of punishment can be anywhere from 0 days to 6 months, which is 180 days in the county jail or anywhere in between. A fine can be anywhere from $0 to $2,000 or anywhere in between. Or you could be given both such fine and confinement. Now, you may qualify for probation. There are two types of probation. One type of probation is referred to as adjudicated probation. We usually refer to that as regular probation. The other type of probation is known as unadjudicated probation. We refer to that as deferred probation. The difference between the two, with the adjudicated probation, it does result in a conviction on your record. However, there is something that is called judicial clemency, which means that the court can set aside the conviction. And the way it works is you have to, one, successfully complete the probation. Two, there cannot be any more time left on the probation. It has to expire. And three, the court has to discharge you from probation. And if those three things happen, the court can set aside your conviction and you will be released from all the penalties and disabilities that are associated with the offense. Any complaint, affidavit, or information will be dismissed. And you can truthfully say that you hadn't been convicted of this case. However, if you get a subsequent or another conviction later on, then this case can be resurrected, revived, brought back up and used against you if you try to get a license with CPS, then they can deny giving you a license, or if you have a license, they can suspend or revoke that license. Now, with the unadjudicated probation or the deferred adjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed. It would not result in a conviction on your record, and you may qualify for a non-disclosure. Non-disclosure means that we cannot disclose the fact that you were on deferred adjudication to the general public. However, if you violate the terms and conditions of your deferred adjudicated probation, the state may file a motion to revoke your probation. If that happens, a warrant will be issued for your arrest. You'll be arrested, brought to jail. Once you're released, or if you're still in jail, you'll have a right to have a hearing for the court to decide or determine whether or not you violated your probation. If the court finds that you have violated your probation, the court can kick you off deferred adjudication, and if that happens, you may get a conviction. If you get a conviction, obviously, your case cannot get dismissed and you cannot get a non-disclosure. If you are not a U.S. citizen, on a plea of guilty or nolo contendere or no contest, it may result in deportation, exclusion from admission, or denial of naturalization. Deportation means that if you're in the country, they can kick you out of the country. Exclusion from admission means that if you're outside the country trying to come in, they can prevent you from coming in. Denial of naturalization means that if you are applying for citizenship, they can deny your application for citizenship. Now, as a defendant in a criminal case, you have three options. One, you may hire an attorney. Two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you would need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and request counsel from the court. Now, the paperwork that was handed out to you earlier have this information on it. And at the bottom of that document, it says defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If your choice is, I have hired an attorney whose name is, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If your choice is, I have a court-appointed attorney whose name is, then you will put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, Then you put your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then at the bottom of the document where it says defendant, you will place your signature there, and where it says date, you will put the day's date, March 23rd of 2021. Now, for those individuals who are waiving their right, who is initialing line number 5, you're waiving your right to an attorney and you want to represent yourself, you would also have to read and sign the next form on the next page, which is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it states, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 23rd day of March of 2021 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel, and if that's your choice, then you will sign on the line that says defendant, and then you will date it today's date, March 23rd of 2021. You also have a right to have a trial by jury. And what a trial by jury is, you have a right to have 6 individuals from Jefferson County to be selected to sit as jurors in your case. They will listen to the evidence, and once all of the evidence has been presented, they will decide whether or not you are guilty or innocent. You also have a right to waive or give up that right to have a trial by jury. And by waiving your right to have a trial by jury, your case will come before the court. That means that it will come before the judge only. It can come before the judge in 1 or 2 ways. One way is what we call a bench trial. If you want to have a trial, you can have a trial before the judge only. Or if you enter a plea of guilty or no contest, then you can come before the court. And for the court, if you have a plea bargain agreement with the state, to see if the court is going to follow that plea bargain agreement. Or if you don't have a plea bargain agreement, and you can request the court to assess that punishment. Now, you also have a right to have witnesses to come to court to testify in your case. And you have a right to ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. And by doing so, you will not be calling any witnesses on your behalf in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. You have a right, for example, to see the videotapes, to tape the audio recordings, the written reports, police reports, or witness statements, etc. Now, you also have a right to give up that right, to waive that right, which means you have a right to say, I do not request discovery in this case. Now, earlier I mentioned you could enter a plea of guilty or no contest. Actually, you have 3 options in your case. You could enter a plea of not guilty, which means that you're telling the court that you did not commit the offense that you've been charged with. Or you could enter a plea of guilty, which basically means that you're telling the court that you committed the offense that you've been charged with, or you can enter a plea of no contest, which means that you're telling the court that you would not be fighting or you would not be contesting the charges against you. Now, for those of you who have a lawyer representing you, or those of you who will be representing yourself, at some point, you'll have an opportunity to talk to the, well, if you're represented by the attorney will have an opportunity to talk to the prosecutors, or if you're representing yourself, you'll have an opportunity to talk to the prosecutors. And the reason why either your attorney or you will have the opportunity to talk to the prosecutors is to see if y'all can reach see if you can reach a settlement. The settlement is usually called a plea bargain agreement. If you are able to reach a plea bargain agreement, that agreement will come before the court, before the judge. The court does not have to follow that agreement. If the court does not follow the agreement that you have made with the state, then you can withdraw, which means you can take back your plea of guilty and no contest without going forward. If the court does follow the plea bargain agreement, however, if you decide later on that I say later on within 30 days that you would like to appeal your case, you have to get permission from the court, from the judge that has followed the plea bargain agreement. If the court gives you permission to appeal, and what an appeal is having a higher court to look at your case to see whether or not an error was committed by convicting you, or to see if you was wrongfully convicted. If the court grants you that permission, your appeal in this county goes to the Ninth Court of Appeals, which is directly above us on the 3rd floor. They will review your case and they can decide whether to either grant your appeal or deny your appeal. If they grant your appeal, then they can either find you not guilty, you could be acquitted of the charges, or they could send the case back down to the lower court or to this court and order that court to give you a whole new trial. Now, if they deny your appeal, then you could appeal it to a higher court than the Ninth Court of Appeals. That higher court is called the Texas Court of Criminal Appeals. It is the highest criminal court in the state of Texas, and it's located in Austin, Texas. You would have to file what is called a pro se petition for discretionary review. Pro se means you'll be doing it on your own without the assistance of a lawyer. You'll be representing yourself. And you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not the court committed an error in convicting you. That court could do one of two things. They could grant or deny your pro se petition. If they grant your pro se petition, they can find you not guilty, which means you could be acquitted, or they can order this court to give you a whole new trial. If they deny your pro se petition for discretionary review, then that process ends. If you enter a plea of, well, first of all, everyone here has been arrested on their case, which means you spent some time in jail, and then you bonded out. The time that you spent in jail for your case can be used as credit toward your punishment. For example, let's say the state is offering you 5 days in jail. Let's say you spent 5 days in jail. That simply means that you would not have to spend any more time in jail because you're given credit for time served. You've already served 5 days in jail. Now, every day that you spent in jail, you get credit in this county as $100 per day. So, for example, you was 5 days in jail, that's $500 that you can use toward your fine and court costs. So if they offer you fine and court costs of $500, you already did 5 days in jail, that's $500. You would not have to pay uh, fine and court costs because the fine and court costs would be taxed and retired because you've already served it out while you spent the 5 days in jail. Now, if you cannot pay the fine and court costs, then there are a couple of things we can do, like convert it to, well, we could put it out on a payment plan, or we can convert it to community service. And every hour of community service that you perform, $12.50 per hour will go toward your fine and costs. So basically, in an 8-hour day, you get $100. So if you work an 8 hour, you do community service for 8 hours, that's $100. Okay. Now, the other thing is Jefferson County has a program that is called pretrial diversion. With the pretrial diversion program, it's for first-time offenders. They have to have a lawyer to assist them at getting into the program, and it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. And if you get into the program, the case is dismissed, and it will not result in a conviction on your record, because the case is dismissed and you may qualify for what is called an expunction. Expunction means that it's erased, wiped off, or deleted from your record. The other thing is there is a program that is called Veterans Court. It's part of the pretrial diversion program as well. And if you are a veteran of any one of the branches of the United States military, you may qualify for Veterans Court. Veterans Court is part of the pretrial diversion program, which means your case is dismissed and you can get it expunged from your record. Okay, and that applies to veterans. So non-veterans is just the regular pretrial diversion, or for veterans, you may be able to get into the Veterans Court. So veterans, I guess you have two options: the regular pretrial diversion or the Veterans Court. Now, the other thing that I would like to mention is that this court, County Court at Law Number 2, has a program that is called the CSI program. CSI stands for Community Safety Initiative. That's a program that I started after being on the bench for about 2 to 3 months. It was a program that basically is designed to address what we call recidivism. Recidivism is people committing crimes over and over. And the way we address it is by making Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. And the program is a myriad or several partnerships that this court have with agencies in the community. This court has a partnership with Spindletop MHMR. They have a mental health program, and they have a drug and alcohol program. And the drug and alcohol program is for people 21 years or younger. And for people who are 20 or above 21, we have what is called Ozar. They're local in the community as well. And with Ozar or even with Spindletop, the Spindletop has a program that's called ATAR. ATAR means Addiction, Treatment, and Recovery. That's what it stands for. And what they will do is do a screening, well, interview screening, and they could develop a treatment plan, either outpatient or inpatient. With the Spindletop mental health, we have some mental health officers and counselors in court. And what Spindletop program, Spindletop has a large facility, but Spindletop has the ability to conduct interviews, assessments, and develop a treatment plan, either outpatient or inpatient. treatment. The other partnership that we have with the Golden Triangle Empowerment Center. Golden Triangle Empowerment Center is or has a partnership with Lamar University. Lamar University has a program that is called CICE, and that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program. You are trained in shipping industry, the hotel industry, or the chemical industry. And then it will assist you with getting jobs in the areas that you're trained in. Now, all of those programs that I talked about is through our partnerships. And I think Spindletop, if you haven't graduated from high school, I think Spindletop has a GED, and I think the CSI program, the CICE program at Lamar has a GED program where you can work and get your high school equivalent diploma. Now, all of these programs that I just talked about, it doesn't cost you anything because they are free. Like that commercial, there's a commercial saying free, 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 free. That's how it's free. Only thing you have to do is have a desire to be in the program. Now, the other benefit of the programs is that all of these the programs that I just talked about, they could be used as community service. So, for example, I tell people this all the time. You can kill 3 birds with 1 stone. And what do I mean by that? You can pay your fine, you can do your community service, and you could be in the program. So, for example, let's say you are working, you're getting trained in the CICE program. Every hour, and then you was ordered to pay a fine and court costs, and then you're in the CICE program. Every hour that you sit in the CICE program, that hour goes to our community service. And $12.50 is going towards your fine and court costs. So you're in the program, you're paying your fine and court costs, and you're doing community service. You're doing one thing, but you're getting credit for 3 things. So you're killing 3 birds with 1 stone. Now, the other thing is, I tell people this all the time, when you come to county court at law number 2 in Jefferson County, Texas, we don't have court as usual. We have unusual court. And the reason why we have unusual court is not because we're different, but because we're trying to make a difference in the lives of the individuals that comes before this court and a difference in the community in which we live. The program is designed to produce productive people. If we produce productive people, then for the most part, productive people do not commit crimes, and it makes Jefferson County a safer place. And the other thing about the program is, of this court, we don't just arrest the problem, we address the problem. Because if we address those problems, then it makes a difference because people will not commit crimes. So if you're interested in the program, just let us know. And as I said earlier, we have folks here from Spindletop who will be happy to share with you the program that they have and the services that they have. We have our mental health officer, Deputy Hinton. He will come up and speak to you and tell you about the program. At this time, I present to you Deputy Hinton.
Thank you, Your Honor.
You're welcome.
Good morning. Like the judge said, my name is Steve Hinton, a mental health deputy licensed by the state of Texas. I work here for the Sheriff's Department. My partner is here with me, Ms. Lisa. She's with Spindletop. She's been here with Spindletop for many, many years. She holds lots of credentials. She's able to handle and address any of the issues that we may come up with today. But we're here for one reason only, because Judge Holmes has graciously allowed us in his courtroom to help everyone here. What we found is people who continue to go in and out of the court system or in and out of the jails are having some type of mental health issues or sometimes substance use disorders. So if we can, as the judge says, if we can address the issues and not just arrest the issues, then we can kind of keep everyone from coming back to court. That's our goal, coming back to court or going to jail. So what we're gonna do today is, I'm gonna be going around and talking to you. If you wish to speak to me, and this is Lisa, we have a private room in the back. All the information that y'all provide for us today is HIPAA regulated, which means it will be protected. No one else will know about it. But we will be able to help y'all with any issues if you find that this is something that you would be interested in. It takes one thing, it takes y'all to ask. You have to ask for us to be able to help. So we're willing to do that. If you have family members that may be suffering from some of the issues, maybe they are directly connected to why you're here today. We'd like to address that with you as well and maybe seek help for them, providing resources, contact information, and guiding you through the spinal top system. Sometimes it can be kind of cumbersome, but we can help navigate you through that if you'll allow us to be a part of that. As we get started, I'll be going around and talking to every one of you. If you want to speak to her, we will make arrangements to go in the back and have a conversation with her. She will speak a little bit more here. Anybody have any questions? Thank y'all very much. Thank you.
All right, thank you, Deputy Henry. The paperwork that you filled out on the tablets, sir, do not drink anything in this courtroom, okay?
Yes, sir.
Now, the paperwork that you have, we're gonna have someone to come by and pick it up, and then we're going to go through the paperwork, and then you're gonna be put in 3 different categories, depending on the way you answered the questions on the form. So it's gonna take us a few minutes to do that. So at this time, we'll be in recess to give our staff an opportunity